Depositions. Depositions are another form of discovery. Depositions are oral questions that are asked under oath of another party. In other words, if I'm taking the deposition of a witness of a party, what I'm doing is going there live or attending by phone or doing it in a videotaped or internet-based fashion, and I get to ask questions of the witness who has to answer them under oath, orally. So, this technique will allow you a little more expansive capabilities than, say, just asking interrogatories or just asking a request to produce, which are both done in written format. If I ask a question, please tell me all the facts which support your defenses or which support your breach of contract action, that's a finite question. The person has the ability to answer. I can't then follow up with them when I have a written paper format, such as interrogatories or a request for production. This is a more active, a more fluid process when I can ask questions of a witness and they can respond and I can follow up from those questions. The purpose of depositions is to gather facts, to learn the exact position of an opponent, to understand what are all the facts that give rise to the case. It is a way of securing information from that witness about things like what other witnesses are available or who might know about this particular case. What other documents are there that might be available that might support or rebut any part of the case. It is also an opportunity for you to learn about the specific position of that witness or that party. It gives you an opportunity to learn the strengths and weaknesses of your case. It gives you an opportunity to essentially lock that witness in, to preserve that testimony. So in other words, once that witness speaks, once that witness says what they have to say, it is under oath and it is forever memorialized in a way that can be useful later. Perhaps a witness is ill and you need to take their deposition because they might not live through a trial. They might have some inability to be available. Perhaps they're traveling out of the country. They won't be available at the time of trial. These are techniques and reasons why you might want to take a deposition. So we have this information and fact gathering. We have this ability to learn about witnesses, this ability to learn about documents, this ability to understand what the type of case they have and how strong their case is and how weak their case is. And you have this ability to preserve testimony, to lock a witness into what they're saying. As I make the famous expression, I don't care what a witness says, so long as he says it. Whatever they say, they're locked in. And it also gives me, finally, an evaluation of my case so that I can determine for settlement or for other strategic reasons what that witness, what that information tells me about my position or my case. So that's the purpose and the techniques that you can use, the tools that a deposition will allow you to garner from that process. So let's take a look at those techniques. Discovery of facts. Well, obviously a deposition is an opportunity for you to ask questions and to get answers. Presumably you're going to ask questions which relate to the facts of your case. They're going to be about that murder. They're going to be about that bloody knife. They're going to be about that car running the red light. They're going to be about the injuries that the individual suffered. They're going to be about what that witness saw or what they know about the case. So this is your chance to ask questions. So you want to be prepared. You want to make sure before you go into a depo, I know what is my point. Is my point to gather a whole bunch of information because I really don't know what the witness knows? Is it to get the witness to say a certain thing? Is it to learn a witness's position so that I can respond with either documents or other witnesses? Is it to get that particular witness to confess something, to admit something? Is it to narrow the scope of what your trial is going to be about? You need to know that before you go in, because that's going to help you to shape your questions. And it's really important that we write down our questions. You should go into a depo completely prepared. You should have all the questions written out. If you're going to use a document, if you're going to use a video, if you're going to use anything other than your mouth, you'll want to talk about exhibits. Those are things which you bring in and use. Like, let's say it's a contract action and you want to show the contract. That would be an exhibit. The process of marking that exhibit, getting it numbered, is a method to allow you to be able to actually ask questions about the document and have that reporter, the person who's taking down the information, track down what they say so that later on you'll be able to understand it. For example, if I'm asking about a contract and I don't say what that contract is, in other words, I don't identify it by a number, you might have a colloquy that ends like this. Well, sir, are you looking at this document? Yes, I am. That document? Yeah, that document. What document? Here. Here? Yeah, there. Okay, on that page, did you sign it? Yes, I signed it. Well, there? No, I didn't sign it there. I signed it here. You could see how, if I read that, I wouldn't know what you were talking about. However, if I asked questions that were along the lines of, let me show you what has been marked as plaintiff exhibit number 1, which is the contract in this case, and I want to ask you about page 3, sir. Where does your signature appear? Then I'm giving a directional type of approach. I am prepared. I'm going to talk about that contract. I'm using an exhibit, and I'm talking in a way that when I read it back later, I will understand what I'm referring to. So preparing those questions up front, being prepared so that you know what to ask, what documents you're going to use, is quintessential, critical to success in the deposition level. The more prepared you are, the more you know about the case, the more you'll be able to not only move forward with your objective, but to respond should that witness somehow say something that you weren't anticipating. So you have a situation here where we are going to go into the deposition, we're going to be prepared, we're going to be able to anticipate those problems, we're going to have our documents available to us, and we're going to flow in an organized fashion. How do I organize myself? Well, I ask myself, what am I trying to prove? What do I want to show through this witness? How am I going to do that? And then how do I order my questions to then do that? What kind of questions do I want to ask? Well, generally, discovery, depositions in particular, are fact-finding missions. They're tools to allow you to learn about things. If I ask you, isn't it true that you're standing in front of me? Or isn't it true that you're watching this? You're probably going to say yes. However, if I ask you, what are you doing today? You might not answer yes or no. You might tell me a lot more things that you're doing. If I say, why are you watching this video? You might have a lot more information to add. So what I want to do is I want to ask open-ended questions. I want to do what I call shrimp netting. That is, throw a big net out, find out everything you know, because I don't know what you know, and then bring that information into me so that I can sort out and pick the good stuff, understand what bad stuff there is, understand how I'm going to need to prepare my case as a result. So I want to ask open-ended questions. Who, what, where, why, when, how. Please explain, please tell me. Those kinds of questions promote a witness to speak. Please tell me all of the facts that govern why you're not paying. Please tell me all of the people who were there when the car ran the red light. Please explain to me all of the reasons why you're not paying for those goods that were delivered to you. Please explain to me where you were on this night. Please explain to me all the things you did to avoid having to shoot that other person. You see, these questions don't call for a yes or no answer. They're calling for an open-ended question. They're an exhaustion tool. I call it an exhaustion technique. I want to exhaust the information from that person. Essentially take a sponge and I want to squeeze out. I want to absorb all of the information I can from them. And most of the time, I'm not going to know all that information. That is why I want to ask the open-ended question. A good tool, good trick, good technique you can use to learn how to do this is to go home today and ask your brother, your sister, your daughter, your father, your mother, how was their day? And then from that question, you're only allowed to ask questions from their answer. So if somebody says, how was my day? Well, it was really tough. I had a very difficult day. It was stressful. My next question would be, tell me how it was stressful. I don't know why it's stressful. I want to learn that. And then they answer, well, it was stressful because somebody ran a red light and they almost killed me. And then I had to deal with this person, and this person was a jerk to me, and it just was very stressful. Okay, tell me about the running of the red light. What happened? Tell me the facts that occurred. Do you see how I'm asking questions from the answer? I'm exhausting that person's knowledge base. If they said to me, hey, the person ran the red light and almost hit me, where were you? Or tell me more about that. And they say, well, you wouldn't believe what happened. You know, I had a green light and I was going through the intersection and the guy swept around some other car and wasn't even paying attention and zoomed through the light. And I slammed on the brakes and they just missed me. I might say, what else happened? Because that would presumably try to tell the witness I need more information. They'll either say nothing or they're promoted to explain. Oh, and let me tell you what else. There was this other car. And then this other car. Do you see how I'm getting more information? So when I ask questions, I'm not only asking an open-ended question, I'm listening to the answer and trying to get more information. I'm taking baby steps. Remember, your objective is to learn information. Your objective is to lock that witness into whatever they're saying. Your objective is to supply, to secure all of that information that you want to get from that person. And you do that in this disciplined fashion. Baby steps. You need to take baby steps. Go slow. Don't be in a rush. Understand it may take time to fully understand every fact that supports why the person was angry, why the person didn't sign the contract, why they didn't pay the bill. So I don't want to make assumptions that what they're saying is everything. I want to make sure I use that exhaustion technique, that shrimp gathering, that way of asking questions that promotes getting all the information. So back to our example. You go through and you ask your friend, your parent, your son, your daughter, how their day was, and then you ask questions from them, see how long you can go. You will find that you can turn a 5-minute conversation into an hour one. And that is essentially because what you're doing is you're listening. And you're asking questions from that to learn more about the person's perspective, what their information is, how they're telling it, because that will tell you something. So all of these tools are life tools, as well as deposition tools, discovery tools. You're learning how to communicate. You're also providing that witness, as well as that sibling or that parent, a vehicle to see you're listening, because you can't possibly ask a question from an answer unless you listen. So listening is a very important skill in this process. The learning of the facts. As we started to discuss about acquiring facts, you need to understand what your case is. If you understand what your case is, then you'll know that while you're performing this exhaustion technique, while you're asking these open-ended questions, you will make sure you cover all the topics. If it's a murder case, you'll make sure that if that's the witness that saw the murder, that you're going to go through every aspect of that witness's background to learn, are they a believable person? Are they a credible person? So that when they tell you their story, will it be believable? And then when the person tells you about that event, I want to learn everything I can about that event. Where they were standing, how they got to that position, what did they see, what else did they see, what else did they see on top of that, what else did they see on top of that, where were they, how did they respond, did someone say something to them, what did they say in return, then what was responded to, and then what was said in return, how many people were present, what did those people say, what did those people see, what did those people do, then what did you do in response? Do you see how I'm going through and I'm exhausting, I'm learning everything I can about that event, that fact, that instance, that evaluation of information is something I need to do to make sure I get all the facts. So I'm discovering facts by asking these open-ended questions, taking my time, making sure that I go through in a systematic, disciplined way. You also have a chance to learn about legal theories. If you have a breach of contract case and you're the plaintiff and you're trying to get the defendant to show that he did not pay the bill, then it is a way of securing information to support that what you have is non-payment, that you delivered the goods, you delivered the t-shirts, you delivered the wristbands, you delivered the footballs, but you were not paid. Your client was not paid. The company was not paid. So you can use a deposition to also understand how strong those facts are to support that legal theory. So, tell me, sir, when you received the footballs. On July 1st, okay? And what did you understand that the contract called for? Well, it called for me to pay $2,000 upon receipt of the footballs. And how were you to make that payment? I was to make that payment based upon either a check or to do it with a credit card. And when did you make that payment? I didn't make that payment. Why didn't you make that payment? Because the footballs were delivered late. Is there any other reason why you ended up not paying? No. Or, yes. Not only that, the footballs were green instead of blue. Whatever the answers are, I want to find out how I show non-payment. Are there justifiable reasons? Do I have a good case for a breach of contract? And I do that by using the information, by asking questions to test those legal theories. I also can use it to preserve testimony, to lock in the witness to what they say. You may need the deposition because that witness is ill. That witness is going to be unavailable. They're going to be in some other country. They're not going to be able to testify at trial because of some justified or unjustified reason. And you want to take their testimony in order to preserve what they say. You can use these tools as a preservation mechanism. You can have the ability to ask the witness questions in a way that once they've said what they've said, I now have it permanently recorded. I now have everything I want them to say, so if they're not there, I can play their deposition at trial. I can read from their deposition. And that ties in also to what we've been talking about before, and that is you got to make sure you get all the information. You got to make sure you've asked the questions in the right way, because if that person's not available, you better make sure the question and the answer are clear enough for a jury to understand. If I don't ask that question in the right way, if the question is objectionable, if there's something wrong with the question where the person doesn't really answer it completely, and now 6 months later, 6 weeks later, or 6 years later, you're in trial, and that person is either passed away or in another state or another country or unavailable, you have nothing. So it's important to understand that these witnesses, these people who are testifying, you need to make sure that whatever you get it clearly, concisely, and you have the answer that you want so that you can use it later. It's also a tool to help you evaluate your case. As you watch the witness, you can see their demeanor. Let's say it's the defendant, and you're determining their demeanor and how believable they are. Maybe it's a police officer who came onto the site, who did some things or didn't do some things, and you want to see how believable, how credible they are, what their background is. Maybe they're a young officer, or maybe they're not experienced, maybe they've been reprimanded, maybe they're not a good communicator. Maybe they saw everything, but they're not a good communicator, and that helps you. Or maybe they are a good communicator, and that helps you. The important thing is to understand that this is a mechanism. This discovery tool, this deposition is a mechanism for you to achieve a lot. To understand, okay, now I am getting information which is useful for me. I'm getting information which can allow me to either gather facts, test material, lock a witness in, or do the other things which are important. A deposition also allows you to impeach a witness, to ask questions of a witness to show that they're either not being truthful, they're not being accurate, or the facts are not as they say it, or to use it to say, you once testified before, or you told the police officer this, but the truth is that. You have an opportunity to show that. You can imagine what it's like if you see on video, if you see on television, if you see live somebody who has to admit they were lying, has to admit they weren't being truthful. What do you believe about the rest of their testimony? So it's important in this pre-trial process, this discovery process, to understand that you can use these depositions as a chance to lock the witness in and to impeach them, to show that they're not credible, they're not believable, they lied, either intentionally or unintentionally. Maybe it's a witness that they lied, but they have a very good reason. Maybe it's a witness you're trying to convey that they're combative and they always make up stuff. Whatever it is, you have a purpose, you have a point, and this deposition allows you to lock that witness in to do that. It's also a way to get admissions. We talked about in the other discovery process that you can send out a written request for admissions. And you can attach a document and say, admit that this is your signature, or admit that this is the only contract in place here. This is the only contract that's relevant to this litigation. Well, you could also, at the deposition, do the same thing. You could take a document out. Let me show you what have been marked as plaintiff's exhibit number 2. Sir, do you recognize that as the check you wrote to my client's company? Yes. Do you recognize that as the gun that you used? Do you recognize that as the gun that you picked up, Officer Smith, at the location? Yes. Okay. That allows me to use the exhibits to actually get that officer to testify to that, to lock them in a way that would be productive later. So you can see that this and many other techniques will enable you to do an excellent job on depositions, to gather information which will be incredibly useful for you, and which you can use in other depositions, other discovery, and for preparation and use at trial.